The Law and You, a look at laws in St. Vincent and the Grenadines which affect our daily lives. The Law and You, presented by lawyer Panel R. Campbell, QC, and brought to you on SVG-TV as a public service.
Ladies and gentlemen, brothers and sisters, boys and girls, greetings. Welcome to another presentation in this public service nation-building series, The Law and You. This is program number 736. On this program, I will continue to speak to you on the topic, freedom of testamentary disposition. This is part 2 of that topic. All right, well, I want to get into the topic for the evening, freedom of testamentary disposition. And I usually consider that persons who listen to one program may not necessarily have heard the preceding program. So there are some of you who would be hearing me speak on this topic for the first time, while others would have heard what I had to say last week, Monday. So if I repeat some of the things I have said before, it is deliberate. I usually do that. Not only within a program. I like to repeat myself because it is a habit I developed as a teacher, knowing that the basic purpose of imparting information is to make sure people receive the information. And not everybody receives information at the same rate or at the same time. So those of you who hear and understand what I say the first time, don't get impatient if you hear it again and again. I am aiming it at those who take a little time to really get to an understanding of what is being said. Because the aim of the program is to impart knowledge. And you impart knowledge by making sure that the knowledge is put over in such a way that even persons of average educational attainment, indeed, even persons of no formal education attainment, once they hear what is being said, could make sense of it. And I feel satisfied when the ordinary man on the street could meet me and stop me and say, well, they heard me say this and that, and they appreciate because they didn't know this and that before. And I thank all of you who follow the program and who encourage me from time to time and tell me that you have been learning things that you had no idea of beforehand. Some of you said it's a pity that you didn't know these things long ago before you had made certain decisions. All right? So to recap, freedom of testamentary disposition means the freedom a person has to distribute by will your worldly possessions. That is, once items belong to you, be it money, furniture, vehicle, a piece of land, property, jewelry, anything that is yours, which you want to make a will and leave for some person or persons, in St. Vincent and the Grenadines, you are free to do what you please with what is yours. I emphasized last week, however, that in some other countries, people do not have that freedom to dispose of their property as they wish. In some other countries, and I cited Trinidad and Tobago, Barbados, Jamaica, Canada, England, other parts of the Commonwealth, you cannot leave out certain family members from your will unless you have excellent reasons for doing so. Under the laws of those countries, not of St. Vincent and Grenadines, under the laws of those countries, you have to leave something in your will for close relatives, spouses, children, other close relatives. And if you don't, when you die and you leave a will and the will leaves them out, they can go to court and complain to the court that the deceased made a will, that they ought to have been left something in the will. The deceased didn't leave something in the will for them or didn't leave enough, and they are not satisfied, and the court will then make a fair apportionment for them if they prove their case. Those countries have what are called family provision laws. However, those laws do not apply in St. Vincent and the Grenadines. So in this country, once a person leaves a will, and once the will is found to have been a true will, that is, made willingly by the person without any force, without any duress, without any undue influence, without any pressure, and the deceased knew what he or she was doing when he or she made the will, and the will is done in proper form, signed by the deceased and witnessed, and the property left in the will really and truly belonged to the deceased. Well, I should say the testator, because at the time when the will was made, the deceased would have been alive. So let us call him or her the testator or testatrix. Once it is shown that what is left in the will belonged to the testator who made the will, and the will is properly made in due form and complying with all the legal requirements, then the wishes of the testator have to be obeyed as those wishes are stated in the will of the testator, in the laws of St. Vincent and the Grenadines. And if the testator leaves out husband or wife or a child or children, the person so left out can't go to court and complain that they were left out of the will and they ought to have been given something in the will. You can't do that in St. Vincent and Grenadines. Not unless you can show that there was some obligation on the part of the person by contract or by some other family arrangement. You have to show that this person was bound to have left you so and so because of such and such arrangement which had been duly made. If you can't show that, you can't just claim an entitlement to property left by the testator just because you are related to the testator by marriage or blood. Now, this brings me to a very important consideration. That is the question of ownership. I have been stressing that a testator can only leave in the will that which belongs to the testator, wholly and solely. So if the testator only had a share in a property, the testator cannot make a will leaving the whole property to somebody who is not the person with whom he had a share. For example, if the testator had a property which he owned in co-ownership with a sister, let us say, then he can leave the property to his sister. The law would interpret that to mean he is leaving his share to the sister who owned the other share in the property. But he cannot attempt to leave the whole property to somebody else because the whole property did not belong to him alone. And I'm sure you will see the sense in that. I gave you the example last time that if this glass doesn't belong to you, you can't leave it in your will for somebody else. if this bottle doesn't belong to you, you can't leave it in a will for somebody else. No, it's not yours. But if you have a half share in the bottle, then you could leave your half share to somebody else. No problem with that. And therefore the question might arise, did the testator own this particular property wholly and solely? Was it his alone? And that question will arise if a will is made by the testator, in which the testator says, I am leaving this property to my nephew Tom Jones. Any person who also had a share in that property could challenge the will. They can go to court and say, no, the deceased could not have left the property to his nephew Tom Jones because I had a share in that property. And the deceased could not give away my share without my consent, and I didn't consent to him giving the whole property to his nephew Tom Jones. And if when the facts are gone into and the judge rules that yes, this person had a share in the property, then the judge will first ascertain what proportion share the person had and what proportion share the testator had when the will was made. If the testator, for example, owned 3/4 of the property, and he attempted to leave the whole property to his nephew Tom Jones, the court will say, no, Tom Jones, the nephew, is only entitled to get the 3/4 share which the testator had in the property. And the other 1/4 share remains the property of the person who held that 1/4 share in the property. So I'm sure you will understand that it is logic, it is reasonable. Otherwise, people would be making wills, giving away that which is not theirs in their lifetime. So you can't just bring a will and say, haha, my name is in the will, I'm entitled to get so-and-so, if it turns out that what the will says you're entitled to get did not belong to the person who made the will. And that is straightforward. Now, the reason I am stressing the point is this. I have explained to you on previous programs that notwithstanding a title deed is in the name of one person, it doesn't mean necessarily that the property represented by that title deed belongs entirely to the person whose name is on the deed. The typical case is that of husband and wife. Two people get married. When they get married, they have practically nothing. They start from scratch. Over the years, they pool their resources. They have children. The husband might be working for money wages. The wife might be a housewife looking after the home. She may have had a part-time job or whatever, but together they pool their resources. And in this context, it's looking for money wages. The law regards a wife as doing an important job as a homemaker. So the wife's role as housewife is regarded by the law as a solid contribution to the matrimonial assets. You see, These are not the days when the man could say, look, I went out on sale. I made the money. All you did, you made children. And you mind the children at home, but you never worked. That is the husband telling the wife, you never worked for a cent in your life. I worked for the money, sent it home. And you looked after the children. It's my money you used to mind the children, my money you used to pay the bills, and therefore you have nothing in that property. My money built the house. You can't say that nowadays. Because the law says, oh no, hold on. Don't regard a wife's duties in the home as equal to nothing. No, the law says she is a partner in this marriage. She held things together. She brought up the children. And even if there are no children, her role is one of a partner, not of a legal domestic. When you marry a woman, she doesn't become your domestic with a ring on her finger. She is a wife entitled to a substantial share. Not necessarily 50-50, I hasten to add. It depends on the length of the marriage, the nature of the occupation of both parties, the value and amount of the assets acquired over time. So many factors will determine what share a court will attribute to the wife and what share to a husband if it comes to an allocation of matrimonial assets. And this exercise is normally undertaken if by chance the couple go for a divorce. If one of them files a divorce petition, then following the grant of the petition comes the question of settlement of matrimonial property. And in this context, the courts daily carry out the exercise of apportioning matrimonial assets between husband and wife, or ex-husband and ex-wife, as the case may be. Depends on a lot of factors, and no two cases are identical, but they are similar. There's principles. But the basic principle is that a husband whose name is on a title deed cannot say that property is mine and mine alone because my name is on the title deed. If the property was acquired during the marriage, and if during the marriage the wife played a role in the home. Now, there are wildly different circumstances. A person might get married. He and the wife drift apart. He then acquires property. Still married, not divorced, but he and the wife are living separate lives. The wife goes and lives elsewhere. And she knows nothing about his acquisition of property. So in that case, if the question arises in court as to the division of the property or shares in the property, the man might be able to show that the wife played no part at all in his building up of assets. But if the wife and him were living together over the years, the fact that his name alone is on the title deed is not conclusive, it's not decisive of the issue. And he can't say, this property is mine alone. No, the courts do not allow you to say that. In fact, the statute law does not allow you to say that. And vice versa. If the title deed is in the wife's name alone, and that property was acquired during the marriage, and the husband had made an input into acquiring the land or building the home, once there is a significant input, then he would be entitled to a share, even though the title deed is in the wife's name alone. So this brings me to the crux of what I am telling you this evening. A husband who has, with the wife, acquired property during the marriage and increased the wealth of the family as a unit, cannot turn around and make a will during the lifetime of the wife and during the marriage. They're not divorced, the wife is still alive. He cannot make a will leaving the whole property to somebody else. He could make a will leaving it to the wife. That would be interpreted to mean that he's leaving his share to her in addition to her share. But he cannot make a will giving away the property or saying in the will that the wife should have a life interest in the property, but when she dies, the whole property belongs to who he chooses now. For the simple reason that in the eyes of the law, that property does not belong to him alone. The wife has a share in the property. So a wife can challenge a will of that sort and say, I had a share in the property, never mind my name was not on the title deed. And my husband could not make a will giving away the whole property or leaving me with only my life interest. And vice versa. If the deed is in the wife's name, the wife cannot make a will in the lifetime of the husband and during the marriage, giving away the whole property to some person, even one of the children, as if the husband had no share in the property. Now, each situation would depend on its own facts, but I'm simply saying that where wills are made by spouses, one has to be careful to make sure that the items identified in the will by the spouse as items he or she is giving to persons other than the other spouse, you have to make sure those items really belong to the person making the will alone. Otherwise, the person making the will would be actually trying to give away property in which the other spouse has a share. Very fascinating. And in case of doubt, always consult a lawyer. Let the lawyer know all the facts of the case, and the lawyer will appropriately advise as to whether you have a case to challenge a will. But other things being equal, you are free once the property belongs to you, or once a share belongs to you. In St. Vincent and Grenadines, you are free to leave it to whomsoever you please. Okay? So that is all from this program of the Law and You, program number 736. I look forward to being of further service to you next week, Monday Divi, for another presentation in this public service nation building series, The Law and You. Do have a very pleasant week, ladies and gentlemen, brothers and sisters, boys and girls, and may the good Lord continue to bless us all.
The Law and You, a look at laws in St. Vincent and the Grenadines which affect our daily lives. The Law and You, presented by lawyer panel R. Campbell, QC, and brought to you on SVG-TV as a public service.